on criminal aspects of business laws, which is an important topic to know the areas that affect the business. Now I request Sri Anil Agarwal Garu, elected president, and Sri Meela Jaydev Garu, vice president, to come on to the dais and occupy their seats. Now I request Sri Anil Agarwal Garu to welcome today's keynote speaker, Mrs. Sushila Ram Varma, advocate and chief consultant of the Indian Lawyer and Allied Services, New Delhi, and Ms. Harini Daliparthy, senior advocate or senior associate, to the dais by presenting a J. Here I would like to recognize the presence of Sri Harish Chandregalli Garu, who is our chair of Corporate Laws and IBC Committee on virtual dais.
Good morning to all the vice presidents, sir, senior vice presidents, sir, speakers, and all the delegates. I'm actually out of station and professional work, so sorry I'm not able to join physically.
Before beginning the session, I would like to show a short film of FTCCI for information of the participants who are non-members, joined online as well as on physical. Mr. Venkat.
The largest business organization of Telangana state. With a legacy of excellence, the voice of the industry, representing the interests of 25,000 businesses of all sizes, sectors and regions. Empowering trade through advocacy, solution and standard setting. Opening new avenues for unprecedented growth. Laying the foundation for an industrial transformation in the state of Telangana. Now, poised for the next century and beyond. The Federation of Telangana Chambers of Commerce and Industry, FTCCI. Together, let's rewrite the vision for a progressive future.
I request Mr. Meela Jaydev to present Ms. Harini Daliparthy, one of the speakers for today's session. Now I request Sri Anil Agarwal Garu to give his welcome address.
Good morning. Sushila Ram Varma, advocate and chief consultant of the Indian Lawyer and Allied Services, New Delhi. Got offices in Mumbai. Harini Daliparthy, senior associate, vice president the committee, Naresh Chandrageli, and co-chair Ritesh Mittalji, members of the management committee, distinguished speakers, invitees, and delegates on and off. Ladies and gentlemen, very good morning to all of you. I am extremely happy to welcome you all to today's important criminal aspects of business laws. A special welcome to today's keynote speaker, Mrs. Sushila Ram Varma, a dynamic, self-motivated lawyer with 25 years of experience and expertise in business, corporate, and commercial laws. FTCCI has planned today's session to provide an overview of criminal offences often alleged in civil and commercial matters and areas that affect the business. Business law is an important part of the commercial legal body, which provides direction on running commercial activities, especially those pertaining to the governing of businesses. Today, understanding criminal aspects of business law is at the heart of the needs of companies and their directors. Indeed, highly restrictive regulations have entirely changed the entire field of business activity, and the consequences of any shortcomings may be decisive for the future of a business and the directors. The business entities, corporate houses, and firms forming a stepping stone to commerce require efficient governance too. The matters relating to setting up and closing an entity, protecting consumers' interests, property issues, foreign direct investments, taxation, and many more, and the disputes arising out of them need to be better understood. I don't want to take much time, as our eminent speakers of the session, Mrs. Sushila Ram Varma and Mrs. Harini Daliparthy of the Indian Lawyer and Allied Services will enrich the participants by sharing their rich experiences. I once again welcome you all and confident that our distinguished speakers will provide valuable input in understanding criminal offences often alleged in civil and commercial law matters. I request you all to take advantage of this meeting, get clarified doubts during the session. This is, in my opinion, it is a niche subject and it is the need of the hour, because challenges of business are increasing day by day, and we do, as a director and as an employee of the company, we should know all the aspects regarding the business laws, which is now converting them into criminal laws. Thank you.
Thank you, sir. Now I request Naresh Chandral Garu, Chairman, Corporate Laws and IBS Committee, to deliver his introductory remarks.
Senior Vice President, FTCCI, Mr. Anil Agarwal, Vice President, Mr. Bila Jaydev, dignitaries on dais, distinguished speakers, invitees, delegates, ladies and gentlemen, good morning to each one of you. I'm extremely happy to add words of welcome to you all today for today's important presentation on criminal aspect of business laws. My special welcome to Mrs. Sushila Ram Varma, Advocate and Chief Consultant, and Ms. Harini Daliparthy, Senior Associate, Indian Lawyer and Allied Services, who have offices in New Delhi, Mumbai, Hyderabad, and Chennai. The Corporate Laws and IBC Committee of FTCCI is actively involved in discussing and debating around various issues relating to corporate laws, insolvency, and bankruptcy laws, and has taken several initiatives in this area along with government and its various agencies to suggest on policies and regulatory changes and to address these issues and acts as a bridge between the policymaker, regulator, and industry participating for development of business in India. A stable and predictable technology-enabled regulatory framework is imperative for a sustainable and attractive business environment. The key to economic and business legislation is to facilitate streamlining regulatory ecosystem and promote business. More so, laws should enable and encourage entrepreneurship rather than act as a deterrent. This session will help the participants to get well versed with the criminal offences often alleged in civil and commercial matters. There is a need to decriminalize commercial disputes, civil offences in business, in Indian business and economic laws, especially concerning to technical offences, unless it includes an element of fraud or wrongdoing. I once again welcome you all for this seminar, and I'm confident that today's meeting will provide us with valuable inputs in understanding criminal offences that are oftenly alleged in civil and commercial matters. Thank you very much.
Before requesting Mrs. Sushila Ram Varma Garu for the technical session, I request Ritesh Mittal Garu to introduce our chief guest to the participants.
Thank you, madam. Friends, it's my indeed pleasure to today's speaker, Ram Varma. is a dynamic and self-motivated lawyer with 25 years of experience in expertise in the business, corporate, and commercial law. She is the co-founder and chief consultant of Indian Law and Allied Services, the multi-boutique law, which provides multidisciplinary services to clients with the object of acting as one-stop shop for all their professional needs. She is a part of various national associations and network of professionals and advise corporate and commercial clients. Through this network, she has been able to service overseas clients with ease and confidence. She is the chief editor of the TIL blog with national ranking in top 10 law. She has started a YouTube program with her team, TIL Legal Speak and TIL Legal Speak to create legal understanding for the public. She has been conferred with various awards and recognitions. With this brief introduction, to take over the session.
A very warm good morning to the participants and the viewers who are present in this presentation on criminal aspects of business laws. Thank you for being with us. In today's day and age, where the commercial world always has to be wary of criminal implications, I would say this is an extremely important topic. It's a very vast topic and not very easy to cover in just an hour's time. However, my team has done their level best to encapsulate the important laws, and we are now presenting the same in a short manner. We'd be happy to take questions after the session is over. Let me begin by bringing to your notice certain vital facts about India. India is reportedly the favorite foreign direct investment destination for global entities today. I think this is something that we should all be very happy and proud of. As per the World Trade Organization and United Nations Conference on Trade and Development reports, India is leading in terms of export of goods and services and FDI inflows. India's global ranking in commercial services is number 7. And in terms of merchandise trade, we stand 21st in the globe. India's global ranking in terms of FDI inflows has grown from $45 billion in 2014 to nearly double in 2021 at 81.7 USD, 81.7 billion USD. When we do business in India, it doesn't matter what kind of entity it is, whether it's a company or a partnership or a proprietorship or a startup, we have to abide by all the legal and regulatory compliances. There are several commercial laws that govern the business entities in India. Some of the important business laws, as we see it, is the Indian Contract Act, the Negotiable Instruments Act, the Information Technology Act, the Companies Act, the Insolvency and Bankruptcy Code, better known as IBC, the Real Estate Regulation and Development Act 2016, better known as RERA, Intellectual Property Laws, Limited Liability Partnership Act again better known as the LLP Act, and Foreign Trade Development and Regulation Act 1992. Now let's see the first act, the Indian Contract Act. The Indian Contract Act provides that agreements, in order to be enforceable, have to have the following elements. Number one, free consent. That is, the parties who have entered into the contract must have freely consented to enter into the agreement. They must have competence to contract. That is, they must be eligible under the Contract Act to enter into a contract. Thirdly, there must be a lawful consideration or an object for entering into the agreement. But what happens if the aforesaid elements are missing in a contract? For instance, A agrees to deliver timely services to B. B pays rupees 10,000 to A. A willfully fails or refuses to fulfill its contractual obligations. The remedies for B are two types in nature. One is civil action, which is for recovery of money, for claiming damages or compensation, for specific performance of contract, or for declaring the contract as void. But B also has other remedies, and that can be criminal in nature. Now, in order to be criminal, B has to prove that there is mens rea or criminal intention on the part of A when she makes an allegation for a criminal action. She further has to prove that there was an intention to commit fraud, cheating, misappropriation, etc. It is only after she is able to do so that there will be an imposition of penalty and imprisonment, or both. Now, the next important question, can one pursue a civil and criminal remedy simultaneously? Yes, says the Supreme Court. There are several cases in which the Supreme Court has observed that civil and criminal proceedings can proceed simultaneously. Whether civil or criminal proceedings can be stayed would depend upon the facts and circumstances of the case. In a recent case, P. Swarupa Rani and Said Askari Hadi, the Supreme Court has held that cognizance in a criminal proceeding can only be taken by the criminal court upon concluding that there exists a prima facie case, and ordinarily a criminal proceeding will always take primacy over a civil proceeding, as disposal of a civil proceeding ordinarily takes very long, and it is in the interest of justice that the criminal case should be disposed of as expeditiously as possible. Now, the next question, what is a criminal offense? A criminal offense means an act or omission made punishable by any law for the time being enforced. A criminal act would mean breaking the law, violation of the law, or offense against the state. What happens when there is a criminal offense? The first stage, allegation of the criminal offense, which is by filing a police complaint or an FIR. The second step, investigation or inquiry by the police into the alleged facts. This is followed by prosecution, which is initiation of criminal proceedings against the accused. And finally, penalty in the form of fine or sentence in the form of imprisonment if the person is held guilty. What constitutes criminal offense in a criminal transaction, in a commercial transaction? The Indian Contract Act is primarily civil in nature, and it falls under the head of civil laws or business law. Contract Act itself does not provide for any prosecution or criminal liability, but certain acts and omissions can constitute a criminal offense if they are punishable by law or comprise of criminal elements such as fraud, cheating, misrepresentation, and criminal breach of trust. What is fraud? If there is an intention to deceive another party, if a promise is made dishonestly without any intention of performing it, or if a fact is communicated knowing fully well that it is false. What is cheating? If a person deceives or induces a person to deliver any property and retains said property, and such dishonest intention exists from the inception, and the retention of the said property is likely to cause damage to the person who has been cheated, it is deemed to be cheating. What is dishonest misappropriation of property? If any movable property is misappropriated or converted to its own use with a dishonest intention, it would deem to be dishonest misappropriation. What is criminal breach of trust? A person entrusted with a property under a contract which is dishonestly misappropriated by the person who has possession of the property. When is a civil act deemed to be criminal? A civil act is deemed to be criminal only if one can establish mens rea. Mens rea is a Latin term which means the guilty mind. It denotes the mental state of guilt, guilty intention, and knowledge of wrongfulness of the act or omission that a person commits. It is only when such mental attitude, that is mens rea, is present in an act or omission, the person who commits it is said to have acted deliberately or dishonestly in defiance of law or acted in conscious disregard of his obligations under the law. The Supreme Court has clearly stated that without the presence of mens rea, the fact can be treated as one that should be dealt with under the civil law and not criminal prosecution. The next act that I would deal with is the Negotiable Instruments Act. As we all know, the Act deals with checks and other negotiable instruments. Section 138, which deals with dishonor of checks for insufficiency of funds, is a criminal offense and has a sentence or fine or both. Imprisonment can be up to 2 years and fine can be up to twice the amount of the check or both. The section, however, allows the drawer an opportunity to rectify the situation by giving him a window of 15 days from the date of the notice is served. In the event that the drawer is capable and complies with the notice, then the offense ceases to be criminal in nature. There is a section 143 that allows the court to decide these cases in a summary manner. There is another section 148 which allows the appellate court to order a mandatory pre-deposit before hearing an appeal, which can be a minimum of 20% or even much higher if the court deems it fit. Another important act is the Information Technology Act, the IT Act, which I would say today is one of the most important acts because of the fact that most businesses are generally done through e-commerce. The offenses under the IT Act mostly have prosecution or penalty or both. The offenses mentioned under section 65 to 74 provide for prosecution and penalty. The punishments that are there in the IT Act are for the following acts: for intentionally or dishonestly or fraudulently destroying or altering or otherwise tampering with the computer source code, for causing damage or introducing virus into the system of another, for sending offensive messages, for dishonestly receiving stolen resources, for causing identity theft, for cheating by personation or by using another's computer resource, for violating privacy, for causing unauthorized access to a computer resource, for threatening the unity, integrity, security of India, which is a cybercrime, for publishing obscene material, including children, in electronic form, and for non-compliance of the requirements and directions of the concerned authority. There are several other sections in which the IT Act makes it an offense punishable under the law. The punishment can be anything between 2 years to 5 years, and the fine can be anywhere between 1 lakh to 10 lakhs. The next very important act is the Companies Act, because it deals with the regulation of the companies, directors, and other stakeholders, protection of the interests of the investors, implementation of effective compliance requirements, and facilitates the ease of doing business. The offences under the Companies Act that are criminal in nature are too many, and as such, I would not like to go through each and every one, as it would take up a considerable time to just introduce all that. However, after this presentation, we shall be uploading this video on TIL Legal Fundamentals on YouTube, and you're free to see the offences which we have mentioned in the PPT. So the offences are generally from sections 57 to 454 and can be inter alia for the following acts: for deceitfully personating as a shareholder to receive the money, for contravening any of the orders of the National Company Law Tribunal, for buying own shares by a company limited by shares or by guarantee, for failure to repay deposits by a company before commencement of the Companies Act. And there are several other offences which I will not go through because it would become very time consuming. One of the important aspects that I would like to point out is that maintenance of books of accounts of companies is mandatory and can also be deemed to be an offence punishable with fine or with prosecution. Thereafter, there are other sections like for committing fraud by the directors, for wrongfully withholding property, for non-compliance of directions given by the adjudicating authority or the regional director. The imprisonment under the Companies Act can range from 6 months to 7 years. The fine can range from 25,000 to 10 crores. The next, and probably a very, very talked about act, the Insolvency and Bankruptcy Code, which consolidates the laws governing insolvency and bankruptcy and resolution of corporate persons, partnership firms, individuals, and companies. The offences under the IBC have prosecution or penalty for both. Offences mentioned under 68 to 187 provide for prosecution and penalty. Again, I will just go through some of the important offences. The first is willfully, fraudulently concealing, removing, transferring property of corporate debtor or destroying or falsifying documents relating to such property by the officer of a corporate debtor. The second, for intentionally defrauding creditors by concealing or removing property of corporate debtors. For false fraudulent entry in books of accounts. For willful omission of material information that is required to be provided by the corporate debtor. For willful contravention of the moratorium or resolution plan by the corporate debtor. I am skipping the other the other criminal offences so that I can go to the next act. There's one thing that I would like to point out, that imprisonment under the IBC can be anywhere from 6 months to 5 years. Fines can range from 1 lakh to 1 crore. Next, the Real Estate Regulatory Development Act, also known as RERA. The RERA is for promotion of real estate sector and to protect the interest of consumers in the real estate sector. There is an efficient and transparent manner of advocating for speedy dispute resolution. The offences under RERA that have prosecution or penalty are few in number. It is only from sections 59 to 68. So the punishment can be for non-registration of a real estate project with RERA or non-compliance of orders issued by the authority. It could be for failure to comply with orders of the RERA tribunal, for failure to comply with orders by a real estate authority. The RERA Act provides for the following punishment in case of the aforesaid offences: imprisonment between 1 year to 3 years, and fine which can be up to 10% of the cost of the real estate project. Another important law, the intellectual property laws, that is the Trademark Act. The offences under the Trademark Act also have offences which attract prosecution and penalty. They are, however, fewer in number, and it is only sections 103 to 109 that can attract prosecution and penalty. Some of the punishments is for applying for false trademark, for falsifying and making deceptively similar a trademark, for selling goods or services in which a trademark description is applied when it is not legal, for selling goods or services without indicating the name of the manufacturer or the place of the manufacturer, for falsely representing an unregistered trademark as a registered one, etc. Now you can see the trademark of McDonald's, which has been followed by another brand called McDonald's. It is so similar. So this is an example where one company is trying to pass off their trademark as one of another. The following are examples of deceptively similar trademarks. You can see there is a slight differentiation between the marks. The Trademark Act provides for punishment from 6 months to 3 years and fine from 50,000 to 2 lakhs. We then have the Copyright Act. The Copyright Act deals with various classes of original works such as literary, dramatic, musical, artistic, or cinema and sound recordings. These offences under the Copyright Act also have prosecution. The offences are mentioned in 63 to 68 and are for the following acts: for knowingly infringing or abetting the copyright in a work, for knowingly making use of an infringing copy of a computer program, for knowingly making or possessing through duplicating infringing copies of any work, etc. Some of the instances of copyright infringement one can see on the screen. The Supreme Court has, in a very recent case which was passed last month in state of NCT versus Delhi, held that infringement of copyright in a work under section 63 of the Copyright Act is cognizable and a non-bailable offence. Cognizable offence is where a police officer may arrest without a warrant. Non-bailable, where the grant of bail is at the discretion of the court. The Copyright Act also provides for punishment and fine. The fine can go up to 2 lakhs. Then we have the Patents Act, which deals with original inventions and works that are known to have been discovered by the person who has made the goods. The offences under the Patents Act mostly have prosecution or penalty of both, and the punishment can be for contravening any of the sections between 35 to 39 of the Patents Act, such as for making or causing to make false entries, for wrongfully using the word patent office at its place of business. Instances of patent infringement are there on the screen, where people are trying to pass off a patent as their own when it already exists. The Patent Act also has fine that can go up to 10 lakhs and imprisonment that can go up to 2 years. Next is the Geographical Indication of Goods, a very important act which helps registration of certain goods that are attributable to a certain geographic origin. The GI under the GI Act mostly has prosecution or penalty, and the punishment inter alia is for the following acts: for applying for false geographic indications without the assent of the authorized user, for selling goods to which false geographic indication is applied, and for improperly describing the place of business, for making or causing to make false entry in the register of the GI. Some of the examples of GI are in the page on the screen. Sadly, the Hyderabadi biryani does not have a GI. It was rejected in 2018 because the person who applied for it could not show the origin in Hyderabad. I can see a lot of disappointment. The next act is the Limited Liability Partnership Act, better known as LLP. This regulates and governs partnership firms which have limited liability. Again, there are sections which have offences which are punishable with fine and with prosecution. I will just run through this because there are too many slides. And there is imprisonment can be anywhere from 6 months to 5 years, fine up to 5 lakhs. Another act, the Foreign Trade Development and Regulation Act, which regulates and governs foreign trade in India. The offences under the Foreign Trade Act mostly have prosecution or penalty. The offences mentioned in 14E provide for prosecution and penalty of the following acts: for contravening or abetting or attempting to contravene the provision of the Act by importing or exporting goods and services of mass destruction. The Foreign Trade Act, read with weapons and mass destruction and their delivery system, provides for the following punishment: imprisonment, which can go up to 6 months and go on till 7 years, or fine, which can go up to these 20 lakhs. There are several other laws which fall under the category of business laws. These are the Indian Partnership Act, the Customs Act, the Foreign Exchange Management Act, the Competition Act, Prevention of Money Laundering Act, Consumer Protection Act, and labor laws. I think I will just leave these acts now and let the next speaker deal with some of the other provisions. In the meanwhile, I am just pulling through some of the acts, for instance, the FEMA, which is extremely important and as far as foreign exchange is concerned, and facilitates external trade payments. The offences under the FEMA are also, there are some offences under 13, 14, and 42 that have prosecution and penalty. FEMA provides for imprisonment that can go up to 5 years, fine that can be 3 times the amount involved. Then we have the Competition Act, which monitors and prevents practices that have an adverse effect on competition, and to promote and sustain competition in markets to protect the interests of consumers. Again, there are offences which are punishable by prosecution. Another important act which is often heard of is the Prevention of Money Laundering Act. The Prevention of Money Laundering Act prevents money laundering and provides for confiscation of property derived from or involved in money laundering. The offences under the Prevention of Money Laundering Act mostly have prosecution or penalty, and the punishment is for the inter alia for the following acts: for money laundering, for conducting a search at a building or place without authorization, for willfully providing false information. Imprisonment can be anywhere between 2 years to 7 years, and penalty up to 50,000. Our next speaker is Ms. Harini. She is a senior associate based in Hyderabad.
Ma'am, for taking the most relevant and important business and commercial laws that also provide for criminal prosecution. Now, I would like to address just a few more business laws that would attract criminal liabilities for offences committed during the course of the business. Taking a cue from ma'am, I would like to next address the Consumer Protection Act 2019, which basically replaces the earlier 1986 Act to provide for better protection of the rights and interests of the consumers, and also establish faster and effective administration for settlement of consumer disputes. This act is particularly civil in nature. However, there are certain offences that would attract prosecution as well as penalty.
For instance, in case of non-compliance of orders that have been passed by the consumer forum at the district, state, and national level. Also, in case of non-compliance of directions passed by the Central Consumer Protection Authority, which basically regulates the matters relating to consumer disputes and in case of unfair trade practices, etc., or in case of publishing false or misleading advertisements, or in case of manufacture, sale, and distribution of adulterated goods or spurious goods. Now, the imprisonment in such offences would be anywhere between 6 months to 7 years, and also in certain cases, life imprisonment. For instance, in case of a death of a consumer who has consumed adulterated goods that is not meant for human consumption, and in such cases, the manufacturer or the supplier of the adulterated goods would be awarded a life imprisonment. Also, a fine may range between 25,000 to 50 lakhs rupees. Moving ahead, the next major aspect of business laws include the labor laws. The labor laws include a number of laws under this umbrella. So I would be dealing with only a few most relevant of the labor laws. To begin with, the Industrial Disputes Act 1947. This act particularly was enacted for the purpose of conducting an inquiry or settlement of disputes per se between an employer and his workmen, or amongst the employers themselves, or amongst the workmen. Now, certain offences do fall under the ambit of criminal prosecution. Say, for instance, an employer has caused an unauthorized layoff or a retrenchment, that is unreasonable deduction of wages and salaries of his workmen, or in case the workmen cause an illegal strike, or the employer causes an illegal lockout, or any person is providing a financial aid to such illegal strikes and lockout, and in case of any misconduct by an employer towards his workmen or vice versa. In such offences, imprisonment may range from 1 month to 1 year, and fine from a nominal sum of 50 rupees to 5,000. Moving ahead is the Minimum Wages Act 1948, which provides that the government in certain kinds of employment fixes a minimum rate of wages payable by the employer to his workmen. And in case the employer is not complying with such government norms, then he would be punished with an imprisonment up to 6 months and fine up to 500 rupees. Also, we have a Payment of Wages Act 1936, which similarly provides for timely payment of wages by an employer to his workmen in certain classes of employment. In case the employer fails to remit such timely payment of wages or salaries, he would be punished with an imprisonment ranging from 1 month to 6 months, or fine from 3,750 to 22,500. We also have a short act called Equal Remuneration Act 1976, which provides that the employer has to make sure that there is no discrimination in payment of remuneration amongst its workmen, neither under the ground of gender nor under any other grounds such as caste, etc. Now, in case there is any form of discrimination in such payment of wages or remuneration, the employer would be punished with an imprisonment ranging from anywhere 3 months to 1 year, and fine from 10,000 to 20,000. The next major labor law that we are going to talk about is the Factories Act 1948, which basically regulates and provides for the working conditions of the employees and the common facilities that an employer has to provide to his employees, such as proper lighting, sanitation, water supply, washroom facilities, etc., to its employees, and certain other safety and health measures that an employer has to
ensure that it's in place in a factory premises. In case the employer fails to comply with any of the provisions of the Act, then he would be liable for an imprisonment ranging from 2 months to 10 years and fine between 500 to 2 lakh rupees. I would be skipping through the Plantation Labour Act because it similarly again provides for regulation of service conditions of plantation labor, like the Factories Act. We would be next dealing with an important labor law, that is the Mines Act 1952. I would like to mention here that the mining industry is a major economic activity in our country. And India is basically rich of large reserves of minerals like iron ore, coal, bauxite, etc. For instance, our neighboring states like Odisha, Chhattisgarh, and Jharkhand, these all states have large reserves of iron ore. So when it comes to mining these minerals, the owner or the agent or the occupier who is in charge of the mining premises has to ensure the safety and health of the employees working in the mining area. For instance, the employer has to ensure that no child below the age of 18 years is employed in a mining activity because it's strictly prohibited under the Act, and also comply with certain other compliances, such as to make sure that the employer discloses the health hazards and any kind of danger involved in such mining activities, etc., to its employees. In case the employer fails to comply with these provisions of the Act, then he would be punished with an imprisonment ranging from 1 month to 2 years and fined from 200 to 2,500. This is a short act we have. Next is the Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996, which again provides for the service and welfare conditions of construction workers employed at a building premises. So similarly, the employer has to make sure that they disclose the safety, any kind of hazards or any kind of dangers involved in the building construction work, and also ensure that safety measures are in place. In case these are not complied by the employer, then imprisonment would be awarded, ranging from 3 to 6 months, and a fine of 500 to 2,000 rupees. I'm going to skip over the Motor Transport Workers Act 1961, because it similarly provides for the working and service conditions of motor transport workers, and the compliance is similar to the earlier labor laws. The next major labor law would be the Contract Labor Regulation and Abolition Act 1970. This act basically governs the employment of contract labor in certain establishments and also abolishes the employment of contract labor in other kinds of employment. Under this act, any regular establishment, not a seasonal one, but a regular establishment wherein there are at least 20 or more workmen involved who are hired either by the organization directly or through a contractor, would have to follow the provisions of the Contract Labor Act. The basic compliances are again similar, that the duties and responsibilities that the employer has to abide by in a establishment are similar to the other labor laws. But the one point that is important here is, in certain kinds of employments, contract labor is strictly prohibited from being employed. For example, state of Andhra Pradesh has notified that in case of organizations that are into core activities meaning that the activity is very essential. The particular, if for example, the manufacturing is very essential to the business of the organization. In such cases, the contract labor is prohibited from being employed, and the regular employees who are actually qualified to do that work have to be only employed. In case all these are not complied by the employer, then imprisonment would be awarded up to 3 months and fine between 500 to 1,000. I would be skipping through the Bonded Labor System Abolition Act 1976, which basically states that an employer cannot employ a bonded labor in exchange for forfeiting the freedom of employment of the workmen. The next important act is the Interstate Migrant Workmen Regulation of Employment and Conditions of Service Act 1979. It is pertinent to note here that although this act was enacted in the year 1979, but this act came into the limelight in the year 2020 when in the movement of the interstate migrant workmen was gravely affected because of the restrictions on the movement during lockdown. And this act basically regulates the employment of such workmen and their conditions of service. Again, this act is applicable to any establishment or even a contractor who has at least 5 such interstate migrant workmen hired by them. And only an establishment that has registered under this particular act can only employ interstate migrant workmen. In case these compliances are not met, then imprisonment would be awarded between 1 year to 2 years and fine anywhere between 1,000 to 2,000. I would be skipping through Dock Workers Safety, Health and Welfare Act 1986. It basically regulates the conditions of service of dock workers at a shipping or dock or port area. So the next important labor law would be the Child and Adolescent Labor Prohibition and Regulation Act 1986. Under this act, a child would be any child who is below 14 years of age and adolescent above 14 years. It basically prohibits the employment of child labor in certain kinds of employment such as hazardous occupations or where the manufacturing or the raw materials or the finished products would cause material impairment to the health of the person employed in such a place. And also there are and in case the employer is not complying with the provisions of the act, then the following punishment would be awarded, that is imprisonment between 1 month to 1 year and fine anywhere between 10,000 to 50,000 rupees. The next major law would be the Employees Provident Funds and Miscellaneous Provisions Act 1952. So this act basically provides for institution of the Provident Fund scheme, the Pension Fund scheme, and deposit-linked insurance scheme or the fund for the employees in a factory or any establishment. Provident Fund is basically something that is in each of these funds. It's basically the contribution made by an employer as well as an employee towards a particular fund that can be utilized after the retirement of the employee or by the dependents in case of death of the employee or in case of early retirement. So in the punishments would be levied in case the employer is fraudulently or for any reason, for any unreasonable cause, is avoiding to pay to make any contribution towards the fund. And in case of subsequent convict, and if he is convicted in the first instance and is again convicted the second time for the same offense, then in that case, the employer would be punished with an imprisonment ranging from 6 months to 5 years and fine between 4,000 to 25,000. Next is the Employee State Insurance Act 1948, which is again basically an insurance that is taken by an employer for the benefit of the employee, so that in case of any medical emergency or for medical treatment, periodical payments can be made to persons either suffering from disablement or in case of death, it can be utilized by the defendants and it can be utilized by the employees in case of sickness, maternity, and employment injury. So under this act, if an employee is making any false statement to obtain such benefit under the Employee State Insurance Act, then he would be punishable under this act. Also, if the employer is failing to contribute to such fund, then he would also be liable under this act, and imprisonment for such offences may range between 6 months to 5 years and fine anywhere between 2,000 to 25,000. There's another short act, that is Maternity Benefit Act 1961. Under this act, if there's a first time expectant mother, then she would be entitled to a maternity benefit for a period of 26 weeks, of which 8 weeks will precede the date of delivery. And in case a mother is already, a woman is already a mother to 2 or 3 surviving children, then in that case, she would be entitled to a maternity benefit of 12 weeks, out of which 6 weeks would precede her expected delivery. And also, in case of adoption, a mother would be entitled to maternity benefit for about 12 weeks. So in case the employer is willfully not paying the maternity benefit during such period to the employee, or in case the employer is dismissing the woman employee during her absence for any of the reasons mentioned above, or is dismissing the woman employee during the 6 weeks immediately following the day of her delivery, or miscarriage or medical termination of pregnancy. In each of such cases, the employer would be liable to be punished with an imprisonment ranging from 3 months to 1 year and fine between 2,000 to 5,000. Similar to the Provident Fund Act, there's a Payment of Gratuity Act 1972, which provides that an employer has to contribute towards the gratuity at the time of, so that the employee at the time of retirement or superannuation, in such cases, gratuity is paid to the employees working in factories, mines, plantations, railway companies, or other private establishments. So who is entitled to a gratuity is an employee who has completed a continuous service of 5 or more years in a regular establishment, or in case of a seasonal establishment, any employee who has been employed for at least less than 6 months is entitled to gratuity at a particular rate. In case of avoidance of payment of gratuity or contravention of provisions of the said act, the person would be imprisoned for a period of 3 months to 2 years and fined between 10K to 20K. I would be running through the Building and Other Construction Workers Test Act 1996, which basically provides that an employer has to pay the cess or the duty on the cost of construction incurred by the employers to the government. And in case he is evading to pay such cess, then imprisonment is only up to 6 months and fine up to 1,000. I will be skipping the Limestone and Dolomite Mine Labour Welfare Fund Act 1972, which is again regulating the service conditions. And this comes to the end of our presentation today. I would just like to conclude our presentation by saying that all the aforesaid business and commercial laws that have been read out to you lay down the legal and regulatory compliances that have to be mandatorily complied by an employer or business entity, companies, startups, partnerships, and even proprietorships that are either already doing business in India or are willing to set up their business in India. It is very, very essential for every person doing business in India to understand that these laws may attract both civil and criminal liabilities for their fraudulent acts and omissions committed during the course of their business. Because it's always better to be vigilant and safe than being sorry later. So for the convenience of the audience, to access this presentation, we've uploaded the presentation on our YouTube channel called TIL Legal Fundamentals. Thank you so much.
Thank you to our speaker, Sushila Ram Varma and Harini Daliparthy. There are a couple of questions. As this session has been taken in a hybrid corporate law and GP company advice serious and also the law. Just the questions will take it. I want guidance on the session. I also press points on these things. Yes. Yeah. Good afternoon, Sushila Varma ji, Harini, and my friends. You have heard last 1.5 hours. So many acts, Madam has gone very in detail, especially criminalization, criminal aspects of business law. The other Madam Harini also has given so many acts. Is it necessary in India now? Small offences, non-serious offences, whether requires a criminal imprisonment, etc. The government, I think, of late has realized to attract the people from abroad and also ease of doing business. And also how best we can, with all these non-serious offences, can be decriminalization, etc. The work is going on. I also understand from the Government of India is working out how best the decriminalization has to be taken. So, Madam has already so many acts. If you read each act, there is imprisonment, either fine or imprisonment, or once they are compoundable or not. Now, suppose if you commit something, immediately they will go and file a complaint before the Economic Offences Court. Now, especially in company law, I have gone through the company law, the 454. The 1956 Act is a much more very good legislation. The 2013 Act has come into force. Now every section has got fine or imprisonment or both or compoundable. That's why, in order to avoid the criminals due to commercial dispute, etc., I think, Madam, Government of India is thinking of decriminalization of these acts. India has got 1,536 business laws with 69,232 complaints across Union of India, state and local laws. Among 1,536 pieces of legislation, 50% are 26,132 laws of imprisonment. Is it at all necessary? In order to attract if any investor from abroad goes to all these things, nobody will come forward. And also now, because the Government of India is how to define how to ease the business, how to run the business, how to enter small investors or entrepreneurs. Now, especially in because there are union laws, state laws, and also state laws and local laws, especially the states of Gujarat, Punjab, Maharashtra, Tamil Nadu, and Karnataka has got 1,000 class of imprisonment. They are their laws, because local laws, 2,000 class of imprisonment, their business laws. That's why what I am suggesting to the Madam also can the Government of India, I think the cabinet is going to meet and consider the decriminalization of all these wherever the imprisonment. Other, who will come to this? Now, if section Companies Act, section 8, it is a non-profitable. If anything has been violated, then it's 10 lakhs or 1 crore rupees is the fine. Even the directors also 3 years or 2,25,000 rupees. All these sections are there. If you see very especially in
Companies Act. I accepted all. I accepted deposits and also these prospectus. All these things are just everywhere they were added. Is it at all necessary for serious, small, non-serious offences? Because either compoundable or non-compoundable. Now I have seen in the HCLT SARS with great respect. In one of the cases for striking of the company, they imposed 26 lakhs. 26 lakhs fines. If you have got 26 lakhs with me, what should I go and revive the complaint? That's why these are all the issues which you have to and also send the comments or citations to the term so that we forward to the government. I think the Union Cabinet Ministry is going to consider after the consider month of May, I think. So they are not considered. I think they are going to consider how best to then remove all the decriminalization of all these. These things, because madam, we are very thankful to you. You have gone through in detail all that. Because there are 1,500 business laws are there, which involves of 69,233 unique complaints across Union of India, government, state governments, and local laws. And out of now, if you stay there, out of 5, every 2 is implemented. If you take 5 laws, then I take example, nearly out of every 5 laws, rules etc. implicit clauses going up to 10. That means every out of 5, 2 are implemented. See, if I want to start a business, and sometimes I am not filed the annual return or the balance sheet, or the reporting. They are not filed immediately. Are the implemented go there. Now they will file all the cases economic offenses. You have to go there and your lot because like that. That is why what I am suggesting. You want to go through the government of India is going to decriminalize the future, for which we shall be very, if they do it, shall be very grateful to the industry, young youngsters who are started work, and it will be very easy job. It is worse. Thank you so much for being here. Thank you.
First, second, there.
New labor code or it's a new social security code amalgamating the earlier so many laws. So have you gone through that, madam, and can you just enlighten us?
Yes, they are being consolidated into a new code. But only the central government has notified these labor codes. State governments are still awaited to notify the rules. Only after which the labor codes will be in impact, and the earlier laws will get repealed, like Payment of Wages Act, Equal Remuneration Act. It will all be consolidated under one law. So what I feel is the number of laws would reduce, but the essence of the law would still remain the same, because even earlier the acts were very short. It was not like it was too lengthy. There are only a couple of 4 or 5 sections in these laws which basically were enacted to ensure that the employer is not in any way discriminating or for following any discriminative policy amongst the workers, like based on the gender, like paying more wages to the men, like male employees, and less to the female employees. So the essence would remain the same. It's only that the number of laws would reduce. That's what I feel, but that will only be implemented after the state laws are also in place.
Ma'am, actually, sir, I just want to regarding decriminalization. So government is taking steps to decriminalize all the acts. They are setting up legal service, according to Legal Services Act, they are setting up Lok Adalat and mediation centers to compound the offences in pertaining to, in place of imprisonment, they are compounding the offense by paying penalty and all that. But one thing I want to ask, ma'am, that regarding check bounces cases, yes, there are the cases are being piled up in all the courts, and though they are made as STCs, but summary trials, but still it is taking more time to dispose of a single case. Nearly 1 year it will take. So I heard from some other sources or might be in paper that the act has been, it might be amended only up to 2 lakhs rupees check will be taken. We can file a case under the check bounce case only if the amount is up to is more than 2 lakhs, sorry. So that the smaller amount, because most of the cases, most of the percentage of the cases are being filed in small amount, like HDFC Bank, corporate bank, they used to file for EMIs. So might be the number of small amount cases are more. So whether the government is amending this regarding that the cases will be only more than 2 lakhs.
Yeah. No, like they may do it. No, you want to go to under file in a because they can one side of the and then they will answer this because even suppose if you go to that one that you can go there and tell them, sir, your lordship, I will immediately that they are closing the matter. And also because they want reconciliation small check over that, not to go to that one.
But see, but you also have to look at the other aspect. Even if it's a small amount, where does the person who is the holder of the check, where does he go? This is at least a quick remedy. When you look at it, when you compare it with the other civil cases, do you know that on an average, it takes 30 years for closure? That is when you go to the Supreme Court, it takes an average of 30 years for each case to close. We have a blog. It's called the Indian Lawyer blog. Yes, you must read. Every case that we are reporting has taken a minimum of 30 years. It is extremely a sorry state of affairs. How do we propose to be a global power with this kind of litigation, lackadaisical and very, very slow implementation?
No, I will add, if check holder holding less than 2 lakhs, etc., we will be spending more than 2 lakhs for all these. It's a fact. How many times you have to go and speak before this?
No, but invariably people try to settle it. They once they get the notice, then they are ready to settle.
రాజు గారు మీరు మైక్ దగ్గర పెట్టుకొని మాట్లాడరండి. రాజు గారు మీరు మైక్ దగ్గర పెట్టుకొని మాట్లాడండి, మీరు ఏదైనా మాట్లాడితే.
Okay, thank you. That madam is telling that they will settle because they go. Yeah. Generally, my Baba, मैं दे देता हूँ या तुम क्यों फिगर करता है ऐसा बोल के ना खत्म कर रहा है. सही. हाँ, ऐसा ही है. Even it depends upon the other councils also. अरे भाई उसको दे दो या क्यों सदा आता है उसको दे दो बस खत्म.
A lot depends on the council.
That depends upon the council. Because especially in even the Companies Act also, operation mismanagement will tell them Baba और बेटी है ना वो सब कर रहा है. अम्मा तुम कुछ नहीं करना बस कुछ ना कुछ करके solve करते. Family matter. There are so many cases are coming up. We have to advise them as a good person. अरे बाबा तुम क्यों करता है यार? तुम क्या? Now we have seen so many cases. Even all the generations died in spite of that.
That's why I said the 30 years is the minimum.
Madam has said 30 years. Like, meanwhile, father died, the elder brother died in one of the cases here. So happened. Yeah, maybe. Yeah. But fighting is if fighting is because unproductive. You can separate mother and father or sisters, they can separate and do their business so that they can earn more than what they are fighting, what for they are fighting.
States that it started that with government is no method. You pay my amount, otherwise there is a criminal aspect. So when they are only with
The private citizen.
the private citizen. At least I guess below the. So any other questions from online yet?
Good afternoon, everyone. My question is not pertaining to specifically criminal aspects of business law, but I want to understand your take on women employees getting leaves for their menstrual cycles. That's the new trend, I should say, that the women employees from business organizations, established business organizations are coming up with. What is your take on it?
Actually, it's a little difficult to answer this because it is something that one should learn to live with. Yes, there are circumstances when things are very difficult, but on one side, we say equal pay for men and women. We say equal opportunities. Then why this distinction? If you talk about maternity leave, one can understand, but I for one am not really in favor of this.
I just answer
Then again it goes, the privacy is not there. The privilege is not there.
Any other questions?
Ma'am, consumer protection. You are having 6 to 5 years time. The copyright or PMLA or IPC can be like regarding that.
No. It's only provided in two. No, one was the consumer protection for death by spurious goods, and the other was for cyber terrorism. Yes. Ah. Yes. Yes.
Other than this, bail provision.
Yes, please.
Recently, I become 2 fellows are now been and the chartered accountant offense first, he has given a certificate based upon which refund is granted by a GST commissioner. Where the GST commissioner, he was suspended department, but the chartered accountant was refused to grant the bail. The chartered accountant
What you have said is actually not a
yeah, but the judge was refused to grant him the bail. You know the reason.
It would be in the order, right? And we also
amount involved? What is the amount?
It was 15 crore the amount was reached.
So that's why you add a chartered accountant to your taxable account as per the Chartered Accountant Act.
GST default is right.
Yeah,
There is a provision.
but there is not any direct evidence involving directly to the officer, and he is not the beneficiary. Yeah, he was not the beneficiary. But I don't know the reason why the judge refused the bail, and the officer who has granted the refund, maybe he should be having some evidence before granting the refund.
As a chartered accountant, you would have certified the account as per the accounting standard.
Yes. Yes.
Then in what way? Because they would have ought to have been given the bail. I don't know how they have refused it and see the grounds why you just been refused to go on an appeal. Yes, even the amounts are there, but your certified as per the books of accounts, etc. General, all the now so many standards have come, schedule 1, schedule 2, like that now. That all these things you might have gone through and certified it, and you should not be blamed. In my view, you should not be blamed.
And he always has the option of trying again before another judge. Or maybe you should change your lawyer.
Why I am asking, because the chartered accountant was jailed, and the person who has granted the refund, he was just suspended. Why he was not arrested?
Very difficult to answer questions like this, which are so vague. Okay.
Ma'am, what was the procedure for getting anticipatory bail like?
Well, for an anticipatory bail, it's mandatory that an FIR has to be registered. If an FIR has been registered, then if you fit the grounds for an anticipatory bail, you can move a sessions court or the high court and explain to the court why you should be given the anticipatory bail, why you fear that you might get arrested, and that you will also have to give an undertaking or a commitment that you will be available for investigation, available as and when you are summoned by the court or any other authority. And in many cases, the court will not look at the evidence at that stage, but it will try and see whether prima facie there's a case against the person who is asking for anticipatory bail. As you know, many a times criminal matters are filed only for putting pressure. So in such cases, I think it would be easy to get an anticipatory bail.
What was the reasonable time period, ma'am?
For
getting an
the minute you know that an FIR has been lodged, you can approach the Sessions Court or the High Court. Okay. Yes, naturally, without the FIR. No, earlier we used to get anticipatory bail even when there was a doubt in the person's mind that he or she may get arrested. But now they say no FIR, we need the FIR number. We need to see what is the allegation made against you, and accordingly we will decide. See, the idea of granting an anticipatory bail is to protect not only the person who's asking for the anticipatory bail, but also to ensure that the investigations go on fairly. And if there is any allegation that has to be proved, it can be proved. That is the entire idea.
FIR, our Telangana government is uploading all the FIR in T app. We can get it free.
That's very good information you've given, because many people don't know that FIRs are available online. So that's an important aspect.
What I request you is, my name is Murli. I'm from Vedavati. I sold my car to Car24. Selling the car, my name is not transferred yet. I did go to transport department. What I did. And that's the to police challan. So we are really confused. We sold the car to an organization and they took all our signatures, and still it is not transferred. If any consequence comes, still as it is in my name, Can I seek your guidance? What are the steps?
Well, first and foremost, you should immediately issue a legal notice to tell inform Cars 24 that you are no more liable for anything, any act that takes place vis-a-vis the car, that you cease to be the owner. So first you should protect yourself, because once you have sent the legal notice and they reply, they cannot say that you have not sold it, right? They have to agree that you have sold it. So then, and you should put a demand and that the transfer should be done, say, within 2 weeks' time, failing which you will take them to court. I mean, that's a threat. I wouldn't advise taking them to court, but what I'm saying is that you should immediately issue a legal notice.
Send an email to them indicating what is going on.
But a lawyer's notice is a little different compared to a threat on email.
That we have given a policy, standard policy is there, you will no longer be responsible, you sold the car to us, they're given in writing. So that's what they have given.
Then you will be absolved. Then there will be no liability on you.
Thank you.
Okay.
That is a buyer's obligation.
That's a buyer's obligation. Otherwise, if anything happens to the car, they get tomorrow, you will come to him. Look here, you are the owner, you paid with them.
Right. So there are few more questions which have come online. I just questions. Yes.
That's an observation, a question. Wow.
రితేష్ గారు, నరసింహరావు గారు ఏదో అడుగుతున్నారు, చేయలేపారు, చూడండి ఒకసారి. నరసింహరావు గారు.
Yes, I want to ask the same thing actually, whether the gratuity is payable to an employee after completing the service of 4.5 years in a company. He resigned after 4.5 years, before 5 years. Is it as per the statute, how it should be?
No, as per the statute, the eligibility criteria is 5 years. So he would not be covered.
Yes, madam, but as per the rounding rules, the 4.5 should we consider as a 5 years?
No. What do you mean by government rules? As per the act, as per the law, it says 5 years. So you'll have to follow 5 years. If it's less than that, you have an excuse, because you can say he's not eligible for gratuity.
But there are some arguments from the employees, as well as some employees are quoting some court judgment citing that the 4.5 years or plus 4.5 plus 1 month or 15 days, 20 days, like that. As per the rounding rules, it should be considered as the 5 years, and accordingly you are liable to pay. That is what we keep on hearing from other sources.
Well, to be very honest, I have not read this judgment, so I cannot comment on it. I'm only going by the Bare Act. Okay.
Okay. Thank you.
The online members can unmute themselves, because I think give them the option of unmuting themselves so that they can answer questions.
Which became defunct during pandemic.
They have reopened. We've been informed that they've reopened.
I think with this, this, we have come to the end of our on behalf of FTCCI, we thank our speakers, Ms. Sushila and Ms. Harini Daliparthy. And as a token of gratitude and
Now we will end this session with a vote of thanks by our Vice President, Mr. Meela Jaydev Garu. Sir, are you online?
Yes, madam. Thank you very much, Veena Garu. And very much thank you to all participants who has joined. Ladies and gentlemen, I am pleased to perform the present task of proposing a vote of thanks on behalf of FTCCI. Thank you, today's speaker, Sushila Ram Varma Garu, for enriching the participants by sharing with her rich experience and business laws and detailed presentation. I also thank you, Ms. Harini, Senior Associate, for her presentation, which is quite valuable and inspiring. Further, I appreciate and congratulate the participants in the today's session, showing the interest and updating of the knowledge on the subject of participating in the event. And participants who are online also, very much thank you. I convey the sincere thanks to members of Federation, Corporate Law IBC committee, members of the managing committee and past presidents, and especially Rajugar was given the good suggestions to our members. And thank you very much, and designated invitees and activities for participation of the programs. And thank you very much for all. Okay.